Hi, welcome to LAWBY podcast. Today's episode is about the rights of LGBTQIA community under Indian law. We aim to explore the challenges they face, the legal protections available to them, and the importance of ensuring their rights are upheld in India. Before we delve into the topic, let's clarify what LGBTQIA stands for. LGBTQIA means lesbian, gay, bisexual, transgender, queer, intersex, and asexual individuals. These diverse identities encompass a wide range of sexual orientations and gender identities. Today, being gay in India can mean being rejected by family, being ostracized by the community, and even facing violence. Ancient narratives of identities. To understand the rights of LGBTQIA community in India, we must consider the historical context. For many years, they faced significant discrimination, social stigma, and legal challenges. In ancient South India, portrayals of same-sex relationships were found in other ancient texts like the Arthashastra, Nardasmriti, and Sushruta Samhita. Indian mythology also contains tales of Vishnu transforming into Mohini to seduce demons and sages. However, contrasting views existed in texts like the Manusmriti, which criticized such relationships. Ancient Indian architecture, like the temples of Khajuraho, depicted scenes of same-sex and bisexual relationships, shedding light on ancient India's thoughts on sexuality. During Mughal rule, unnatural intercourse was prohibited under the Fatwa Alamgiri based on Sharia law, leading to punishments such as lashings for engaging in homosexual intercourse. This attitude continued in later times, as seen in the obscenity charges faced by the writer Ismet Chugtai for her work Lihaf, which explored lesbian love and inspired the famous 1996 movie Fire, until its decriminalization in 2018. India's first codified legislation on homosexuality was Section 377 of the Indian Penal Code 1860. We will discuss the impact of Section 377, which criminalized consensual same-sex relationships until its decriminalization in 2018. Section 377 of the Indian Penal Code, criminalizing love. Section 377 of the IPC states that whoever voluntarily has carnal intercourse against the order of nature with any man, woman, or animal shall be punished with imprisonment for life or with imprisonment of term which may extend to 10 years and shall also be liable to fine. It imposes severe punishments equivalent to heinous crimes like rape or culpable homicide on those engaged in such activities. While this law has some impact on heterosexual couples, its effect on homosexual partners is particularly harsh. Although not explicitly mentioning homosexuality, it led to discrimination against the LGBTQIA community, considering their sexual activities as unnatural and abomination, even when conducted consensually in private. This statute had far-reaching implications on the physical intimacy and rights of the LGBTQIA community in India. Decriminalization and legal protections. In historic judgment in Naute Singh Johar v. Union of India, the Supreme Court of India decriminalized consensual same-sex relationships. We will discuss the landmark cases on the decriminalization of Section 377 and how it recognized the rights of the LGBTQIA community in India. NAS, an NGO based in Delhi, filed a public interest litigation challenging Section 377's constitutionality, arguing that it violated Articles 14, 15 and 16 of the Indian Constitution. The court declared that Section 377 IPC, insofar it criminalizes consensual sexual acts of adults in private, is violative of Articles 21, 14 and 15 of the Constitution. The provisions of Section 377 IPC will continue to govern non-consensual and penile non-vaginal sex involving minors. By adult we mean everyone who is 18 years of age and above. A person below 18 would be presumed to be able to consent to a sexual act. The judgment delivered by the Supreme Court in the case of National Legal Service Authority v. Union of India recognized transgender people as citizens with fundamental rights, including the right to privacy and autonomy. This judgment set comprehensive guidelines for their inclusion in public spheres and remedies for marginalization. The case of Justice K.S. Puttaswamy v. Union of India expanded the right to privacy to include all individuals regardless of their gender or sex, providing autonomy and protections for members of the LGBTQIA community in making choices about their partners. Together with the NALSA judgment, it paved the way for the decriminalization of Section 377 in 2018. In the case of Navtej Singh Johar versus Union of India, Ministry of Law and Justice, Supreme Court stated that the LGBT persons deserve to live a life unshackled from the shadow of being unapprehended felons. The conclusion of the ruling states that LGBT individuals deserve to live without the fear of being considered criminals. The court declares that Section 377 is unconstitutional as it criminalizes consensual sexual acts between adults in private. However, the ruling does not reopen concluded prosecutions. The provisions of Section 377 will still apply to non-consensual sexual acts, acts against minors, and acts of bestiality. Rights to marriage and adoption, struggles and triumphs. While decriminalization was a significant step forward, the rights of LGBTQIA individuals are still evolving in India. We will discuss the case law that have challenged existing norms and advocated for equal rights in these areas. Two same-sex couples have submitted writ petitions to the Supreme Court of India and a verdict is yet to be passed, seeking legal recognition of same-sex marriages within the country in the case of Supriyo alias Supriya Chakraborty vs. Union of India. These petitions primarily focus on the constitutionality of Special Marriage Act 1954. The first petition was filed by Supriyo Chakraborty and Abhay Dang, while the second petition was submitted by Parth Feroz Mehrotra and Uday Raj Anand. The crux of the petitioner's argument lies in Section 4, Subclause C of the Act, which currently only recognizes marriage between a male and a female. According to the petitioners, this provision discriminates against same-sex couples as it denies them various matrimonial benefits including adoption, surrogacy, employment, and retirement benefits. Consequently, the petitioners are urging the court to declare Section 4 Subclause C of the Act as unconstitutional. This plea has been combined with several other petitions that challenged different personal laws on similar grounds. Notably, among the challenged enactments are the Hindu Marriage Act 1955 and the Foreign Marriage Act 1969. The petitioners contend that the lack of recognition for same-sex marriages infringes upon their right to equality, freedom, expression, and dignity. However, in the case of Arun Kumar Srija vs. Inspector General of Registration, the Madras High Court expanded the category of brides under the Hindu Marriage Act to include trans women. This judgment upheld the principle of self-identification, allowing individuals to identify as any gender without external verification. It laid the foundation for broader marriage rights within the LGBTQIA community, affirming their constitutional right to identify and marry according to their gender identity. In India, adoption falls under the purview of three main acts: the Hindu Adoption and Maintenance Act 1956, the Guardianship and Wards Act 1980, and the Juvenile Justice, Care and Protection of Children Act 2015. Under the Hindu Adoption and Maintenance Act 1956, adoption is restricted to married individuals or single males or females who are governed by Hindu laws. For those of other religions such as Muslims, Christians, Parsis, and Jews, the option of becoming guardian is available under the Guardianship and Wards Act 1980. However, the Juvenile Justice, Care and Protection of Children Act 2015 allows adoption regardless of adopter's religion. The procedures for adoption under this Act are detailed in the Adoption Regulations 2017, which are formulated by the Central Adoption Resource Authority (CARA), a statutory body under the Ministry of Women and Child Development. Notably, the law does not expressly prohibit same-sex couples from adopting, but it does require that married couples demonstrate at least 2 years of stable marital relationship to be eligible for adoption. As a result, marriage is generally a prerequisite for adoption in most cases, creating a challenge for same-sex couples since same-sex marriages are not recognized by the government. As of the current situation, the right to marriage and adoption for same-sex couples remains unaddressed in India, as the courts are yet to arrive at a definitive conclusion regarding the recognition of these rights. The pertinent issue is the subject of numerous pending cases awaiting verdicts to determine its legal status in the country. Until a conclusive decision is reached, the legality of same-sex marriage and adoption remains uncertain. Breaking the chains. In conclusion, Despite significant progress in recent years, it is evident that the LGBTQIA community continues to face discrimination and backlashes. While landmark legal decisions and societal shifts have paved the way for greater acceptance, there is still much work to do done in achieving true equality and inclusivity for all. It is crucial for individuals, communities, and governments to actively challenge, prejudice, promote understanding, and protect the rights of LGBTQIA individuals. Only through collective efforts can we create a world where everyone can live without fear of discrimination and where diversity is celebrated and respected. Thanks for listening. That's it for today's episode. Follow, share, and subscribe. Stay lobbyfied.